All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Thank you.
Good morning and welcome everyone in and outside the courtroom. Apologies for the 5 minutes delay. We had a technical issue with IT. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is file KSC BC 2023-10, the Specialist Prosecutor versus Sabit Januzi&Bahtijari&H.Shala.
Thank you, Madam Court Officer. Now I will kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Good morning, Your Honor. For the Specialist Prosecutor's Office, we have Case and Evidence Management Assistant Aniko Bulldog, Senior Prosecutor Nathan Quick, and myself, Prosecutor Tasneen Shahabuddin.
Thank you, Madam Prosecutor. Now I turn to the defense, starting with the defense of Mr. Januzi. Mr. Rees, you have the floor. Microphone, please.
Your Honour, I am Jonathan Rees, King's Counsel, Specialist Counsel of Mr. Sabit Januzi. I'm assisted by Mr. Co-Counsel Hugh Bowden and also Mr. Muharremi Halilai.
Thank you, Mr. Rees. Now I turn to the defense of Mr. Bahtijari, please.
Good morning, Your Honour, and everyone in and outside the courtroom. My name is Dr. Felicity Gerry, King's Counsel, and I'm here on behalf of Mr. Bahtijari as his counsel.
Thank you, Ms. Gerry. I note
It's
that
actually Dr. Gerry, not Miss, it's Doctor.
Thank you, Dr. Gerry. Is that okay?
Thank you. Yes, thank you very much. It took me 7 years to get it, so I do try and use it. Thank you.
I note that you are representing Mr. Bahtijari and that the previous request related to the representation of the accused is moot. And also note that Mr. Bahtijari is present in the courtroom for the status conference.
Thank you very much.
Now I turn to the defense of Mr. Shala, please.
Good morning, Your Honour. Toby Cadman, Specialist Counsel for Mr. H.Shala. I'm assisted today by John Cubban, Co-Counsel.
Thank you, Mr. Cadman. And I also note that Mr. Shala is participating via video conference for this status conference. Finally, the registry. Mr. Nilsson, you have the floor.
Good morning, Your Honour. Good morning, colleagues. Jonas Nilsson, Deputy Registrar for the registry today.
Thank you, Mr. Nilsson. And for the record, I'm Nicolas Guillou, Pretrial Judge for this case. On 8 February, I scheduled this fourth status conference in this case 10. My goal today is to review the status of the case and to further organize the exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss, first, the issue of funding the defense teams by the Ministry of Justice of Kosovo that has been raised by all defense teams in their written submissions. Then, disclosure of evidentiary material, the status of the specialist prosecutor's investigations, the points of agreement on matters of law and fact, the status of defense investigations, the anticipated transmission of the case file and when the parties expect to be ready for trial, and finally, any other issues the parties may wish to raise. I thank the parties for their submissions ahead of this status conference. And as usual, I will invite the parties and the registry to present their views in a concise fashion about each item in the agenda that I will address individually. I remind the parties and the registry that should any submission require disclosure of confidential information, prior notice should be given so we can go into private or closed session. Before we move to the first item on the initial agenda, I would like to hear the parties and the registry on the issue that has been raised by the defense teams in their written submissions, namely the funding of the defense. I note that in its submission for the status conference, the Januzi defense raised the issue of failures on the part of the Ministry of Justice of Kosovo, as a result of which defense funding is not yet in place, with no timetable for resolution. The Bahtijari defense indicated that several requests for confirmation of funding were made to the Ministry of Justice of Kosovo. A funding meeting was scheduled last week, but it has been cancelled with no confirmation that funding will be received. And I have been notified yesterday by email that a meeting was supposed to be scheduled today, so I will invite Council to give an update on this matter. The Shala defense also indicated that its investigations are subject to funding being guaranteed by the Ministry of Justice of Kosovo. So I would like to hear from each defense team what is the current situation, if there's been any update, and if there is a prospect of finding a solution soon. I invite the defense to indicate if they have raised this issue with the registry, and if so, what solutions have been discussed. And I also specifically invite the Bahtijari defense to indicate the reasons for its request to stay the proceeding for a month. I will first give the floor to the Januzi defense team, starting with Mr. Rees. Please, you have the floor.
Thank you, Your Honour. Your Honour, the law on legal protection and financial support for potential accused persons in trials before the Specialist Chambers, law number 05/L-054, requires the Kosovan state to provide legal protection and financial support covering the costs of the defence and engagement of independent experienced counsel to any person who is accused of crimes alleged in proceedings before the Specialist Chambers through secondary legislation to be administered by the Ministry of Justice. That law specifically does so, recognising, it says in the preamble, the sacrifice, commitment and contribution made by the Kosovo Liberation Army and its soldiers in bringing freedom and independence for the people of Kosovo, and secondly, reiterating, as it states in the preamble, its commitment, that is the commitment of the Republic of Kosovo, to protect the rights of all its citizens. The relevant secondary legislation empowered by law number 05L-054 is Administrative Instruction MOJ number 8/2022. Under that administrative instruction, the defence for Mr. Januzi made a request in accordance with its terms on the 4th of December 2023. Under the terms of the administrative instruction, the Ministry of Justice has 10 days for the Commission that it is obliged to have in place to respond to the request, to rule on it and deal with it. We have repeatedly pressed the Ministry of Justice to deal with the request, firstly within those 10 days, and then subsequently at the Ministry of Justice's request via inter-parties correspondence to delay the matter while they were addressing what we were told was a lack of numbers on the Commission. So we were repeatedly given dates in which the Commission would meet, only to then be told that, in fact, they were going to delay it further. And that process has continued throughout December, January, February, even as recently as this week. We have attempted to remain as cooperative as we can and have relied on the repeated assurances that things would be dealt with, but to our failing, to our cost, because no meeting, as we presently stand here today, has yet communicated any decision to us. And I can't, Your Honour's asked for an update as to when the defence expect this to be resolved. I can't give Your Honour that update because I can only convey to Your Honour what we've been told in the past, which is it's being dealt with imminently, for us only to be to find out that, in fact, it's been delayed again. So I am not in a position, realistically, to convey any timetable to Your Honour. I can say that we were told that there would be another meeting scheduled this week. But whether that happens or not, we wait to see. What I do invite Your Honour to do as a matter of constructively assisting in us proceeding further with this is to direct the Ministry of Justice to comply with its legal obligations under law number 05/L-054 and administrative instruction MOJ number 08/2022 as in force on the 4th of December 2023 when the application was made for legal expenses cover. It seems to us, having considered it, that it's perfectly within the jurisdiction of the Specialist Chambers. In fact, arguably falls exclusively within the jurisdiction of the Specialist Chambers to deal with because law number 05/L-054 and the relevant administrative instruction deal only with proceedings before the Kosovo Specialist Chambers. Deals with no other proceedings. And, of course, this court has primary and exclusive jurisdiction over matters dealing with its own proceedings. So I do invite the court to give that direction to the Ministry of Justice. If either the court doesn't feel able to or not willing to, or does, and I would invite Your Honour, if Your Honour does make such a direction, to put a time limit on it, and an urgent time limit in the circumstances. If there is failure to comply with that, it seems to us the next course of action is for us to seek a referral to the Constitutional Chamber. And again, we would invite the assistance of the court in ensuring that this matter is dealt with as expeditiously as possible by the court making a referral itself to the Constitutional Chamber so that they can consider the issue if this failure to comply with the obligations that the Ministry of Justice has under law number 05/L-054 and administrative instruction number 8/2022 as in force on the 4th of December 2023 continues. Those are our submissions, and I hope that we move as promptly as possible to a position where this issue can be left behind and we can concentrate on other matters.
Thank you, Mr. Rees. Now I turn to the Bahtijari defense. Dr. Gary, please.
Your Honour, in the interests of expedition, may I adopt the submissions made by Mr. Rees and make the same requests that Mr. Rees has made on behalf of Mr. Bahtijari? To answer Your Honour's questions when you opened this particular topic, we are in a similar position. We have made several requests of the Ministry of Justice to answer our application for funding. And when it became clear that the meeting that was not going to go ahead last week of the Commission, I notified the registry myself that there was a problem and the Specialist Prosecutor's Office, and I hope that those messages came through to Your Honour. The role that I took was to let everyone know that there was a problem. As I understand it, last week there was due to be a Commission meeting, but one of the members had a family emergency, for which, of course, I sent my best wishes to that person. I don't know who it was, and I hope it was not too unpleasant. And I made further requests as to when a meeting was to take place or whether funding would be confirmed. At the point at which I made written submissions to Your Honour to delay the case for a month, I was not receiving any clear answer about the defence funding. And I knew, absolutely confident, that Your Honour would wish to focus on the fair trial rights of the accused to ensure that they have equality of arms and suitable representation. I'm a senior member of my profession, and I take very seriously the importance of the fair trial rights of the accused. I have relayed those opinions of mine to the Ministry of Justice, and the head of the relevant department indicated yesterday that there would be a meeting today of the Commission. The phrases used in the emails by the head of that department to me indicate that they understand the urgency of the situation. There has never been an email suggesting that funding will not be granted. It does appear that they need the Commission to meet to tell us what that funding will be. So as I sit here now, I don't know what the funding situation is. I'm hopeful there is the meeting today, and I'm hopeful that my team will be funded. In very short form, I can say this, that I cannot attract a Kosovan speaker to my team, because a Kosovan speaker will not join an unfunded team, which means that Mr. Bahtijari's right to an interpreter is affected. I should say that the Defence Coordination Office and the detention facility have been very helpful up to now, but I have been told that I'm not entitled to an interpreter, although they have provided one for all of my meetings with my client. I have raised with Your Honour, and I don't wish to say much more in public session, that I have concerns about Mr. Bahtijari's health. I have raised 3 health issues with the detention unit. I haven't yet received a reply, but they've been very helpful so far. I would wish to have a health assessment of my client before I can say that he is fit to stand trial. I don't have any funding to obtain that health assessment. I am currently online because I am not funded. So I have been working, certainly since I had access. I was appointed on the 4th of January, and I had access to workflow on the 19th of January. I'm working as fast as one person can, as is humanly possible, but unfortunately without a team, and this is a case that requires a team, I am inhibited in the sense that I am plainly discharging my obligations as counsel with a very frustrating situation as far as funding is concerned. There are a number of other issues, as you can imagine, and I'm sure with Your Honour's experience, you understand how difficult it is to represent anyone, let alone in an international court, without any funding at all. I should end with, I have read the highly insulting submissions by the Specialist Prosecutor's Office. I don't propose to address those. If you ask me about them, I shall answer, of course. I expect an apology for that appalling submission. And as a senior member of my profession, regulated by 2 domestic jurisdictions and obligated to this court and my client, I find it offensive that anyone would attack counsel rather than focus on the fair trial rights of the accused. So my situation is this. I hope today there will be a grant of suitable funding for Mr. Bahtijari's team so that we can crack on and make sure there is no delay in this case on his part, but to include a health assessment. I suppose the only thing I can do today is to ask you to adjourn this status conference so that the Ministry of Justice reply with that direction that Mr. Rees has requested. Can we have a direction that they indicate the situation with funding and perhaps come back tomorrow so that we can give you a clearer update? In the meantime, I'm a bit stuck, if I'm honest. It's cruel and unfair to Mr. Bahtijari, and we need the court's help to make sure that Mr. Bahtijari's fair trial rights are observed. Those are my submissions.
Thank you, Dr. Gary. Now I turn to the Shala defense with Mr. Kedman, please. You have the floor.
Thank you, Your Honour. So the position is this. I won't repeat anything that Mr. Rees or Dr. Jerry has already said in terms of what the communications with the Ministry of Justice. Obviously, that affects us as well. What I can say is that certainly I have given an undertaking to Mr. Shala, irrespective of the funding decision. The defence continues. Obviously, we will need a decision by the Ministry of Justice. We have discussed with Mr. Shala, if a negative decision is made by the Ministry of Justice, then we would need to then pursue legal aid funding through the specialist chambers. But certainly, as Mr. Shala is in detention, has been in detention now for 2 months, we certainly do not want to delay the situation any further. All I can say is that, as is set out in the written submissions, of course, in terms of the long-term defence investigations, it may have an impact depending upon what decision is made as far as funding is concerned. But let me just repeat again, I've made it absolutely clear to Mr. Shala that that is not in any way going to impact on the manner in which he is represented in these proceedings. That is an undertaking that we have given to him, and I fully recognise the obligations of which I'm bound, both within the framework of the specialist chambers and as a member of the Bar of England and Wales. And Your Honour, that's really all I can say at this stage.
Thank you, Mr. Cadman. I will now give the floor to the SPO. There was a confusion with the channels. I will give the floor to the SPO, but just to address the request to stay the proceedings. We will not going to discuss about your request. I think it's F-173 that you filed yesterday, and that has been raised by the defense today. This will be dealt with written rulings and written submissions, but just on the request of the Bahtijari defense to stay proceedings, please, Madam Prosecutor.
The SPO would oppose any request to delay the proceedings in light of this funding issue that's been laid out for us in some more detail here today. I think the main point here is that this court, the specialist chambers, has a functional and comprehensive framework to handle funding and representation matters, both in terms of potential legal aid and the appointment of duty counsel, as stopgap procedures, and all of those rules are designed to ensure continuity of representation, including the avoidance of delay. And so without information about how particularly the registry has been engaged with in a formal way, as opposed to simply notification, which I understand has been made by at least one of the parties at issue today, the SPO can find no reason that anything should be delayed. As my colleague, the counsel for Mr. Shala, has indicated, the obligations of counsel in this circumstance, whatever circumstances may arise per the directive, are to fulfill their duties in the way they would at any other time. And so the SPO would oppose the request for a delay made by counsel for Mr. Bahtijari.
Thank you, Madam Prosecutor. Dr. Gary, do you want to reply to the SPO on this issue, specifically to the issue of your request to stay proceedings?
Yes, I do note that the Specialist Prosecutor's Officer did not refrain from, as you requested, from making comment about the obligations of counsel. So I do note that the Specialist Prosecutor is still raising those issues in a public hearing, which I find extraordinary and offensive. On the application to stay the proceedings for a month, in our submission, Mr. Bahtijari's fair trial rights should be recognised. That involves him needing a team that amounts to equality of arms with the prosecution, who have at least 3 people there today. It requires him to have a Kosovan member of the team. I have indicated it requires a health assessment, and all of that requires suitable funding from the Ministry of Justice, who so far have not indicated there will be no funding. The suggestion by the Specialist Prosecutor's Office that somehow there should be a stopgap of duty counsel, in my opinion, in my submission, is appalling. The idea that duty counsel should appear as against a full prosecutor's office is not equality of arms. We are not seeking to delay the process here. I have been in place working in my position as counsel since the 4th of January, properly representing Mr. Bahtijari, but the funding situation does not allow him to exercise his fair trial rights. And in those circumstances, it is obvious in our submission that it will take at least a month to sort these things out. It isn't just a question of saying, right, here's some money, get on with it. It's about making sure that we have the health assessment, that we have a suitable team, that everyone is allocated to a task, and that we can respond properly to the suitable findings of the suitable filings of the Specialist Prosecutor's Office rather than insults. I appreciate that this court would not wish to stay proceedings for a month, but in my submission, making sure that the fair trial rights of an accused person in this court are properly protected and not violated will take a month. And in those circumstances, in our submission in relation to a stay remains, during that month, of course, I would expect to have to give you, Your Honour, and the registry and everybody else notice as to our position as far as funding is concerned, including another meeting tomorrow, another status conference tomorrow if necessary. But our submission remains that this seems to have drifted, at the very least, until I was appointed. And I have put my foot on the pedal, notified everyone that this is a crisis. It is a serious problem. It is serious enough to stay the proceeding for a month. And in order to ensure that Mr. Bahtijari's fair trial rights are not violated, it is my request that that happens, obviously, with regular updates to this court and the registry and everyone else. Those are my submissions.
Thank you, Dr. Gary. Madam Prosecutor, you request the floor?
Yes, Your Honor, I would just seek to reply.
Briefly, please.
I can be brief. I just want to point out that counsel refers to funding mechanisms that are provided through an administrative instruction of the Ministry of Justice of Kosovo. That lies outside of the framework of this court, of the specialist chambers. What I didn't hear is any justification as to why counsel has not engaged with the registry in order to make use of the framework, the robust framework that is in place for the specialist chambers.
Dr. Gary, please, you will have the floor, and I give you the floor. I will give you the opportunity to respond, but we will first listen to Madam Prosecutor, then you will reply, and everyone will be able to listen to each other. Thank you very much.
May I question?
No, you don't have the floor now. You don't have the floor now. You don't have the floor. I'm the one distributing the floor in this courtroom. Let me be very clear. You will have the floor to express yourself. Now the prosecutor has asked to have the floor again. I gave her the floor. I told her to be brief, and I will give you the floor afterwards. But I will not tolerate that this courtroom becomes a place where everybody talks on each other and nobody understands anything. I want to hear what all of you have to say, and I cannot hear if you all speak on each other. So please, Madam Prosecutor, proceed. And Dr. Gary, you will have the floor afterwards.
I'll just complete my thought, which is that there is a fully functional, comprehensive framework in place before the specialist chambers that would involve counsel making a formal request or application of the registry, and that would in some way address funding. There are various mechanisms to address funding within the scheme that is already in place before the specialist chambers and doesn't involve the government of Kosovo or any other outside funding scheme.
Thank you, Madam Prosecutor. Dr. Gary, now you have the floor, please.
I'm aware of what funding mechanisms there are. I joined a case where, as I understood it, the funding would come from the Ministry of Justice. Nothing that the Ministry of Justice has communicated is to suggest otherwise. Those processes are in place. The specialist prosecutor keeps repeating the insults about me, and you ordered them not to make those submissions. We are losing sight of the fair trial rights of Mr. Bahtijari. I understand what the funding mechanisms are. In my submission, the Ministry of Justice should honour its obligations. You should direct the Ministry of Justice to respond. We should have the opportunity to go to the Constitutional Court if their response is inadequate. If all of those routes for justice fail, I understand what alternative routes there are. In the meantime, my client's case was not progressed until I came into this case, and he is outstanding a Kosovan speaker and a health assessment and a proper team to represent him as a result of a funding crisis that violates his fair trial rights. In my submission, you should reject the arguments of the Specialist Prosecutor's Office, which are a thinly veiled attack on defence counsel and highly inappropriate. And I do invite this court to have another status conference tomorrow so that we can give you an update as to funding from the Ministry of Justice, please.
Thank you, Dr. Gary. I see another request for the floor.
Yes.
Mr. Rees, please.
I would like to address some of the thoughts, as they were put, of the prosecutor from the SBO. The law on legal protection of financial support for potential accused persons in trials before the Specialist Chambers Law number 05/L-054, together with the administrative instruction MOJ number 08/2022, is part of the legal framework of the Republic of Kosovo that deals solely with these proceedings. There is an alternative route for legal aid funding that is provided under another scheme operated by the Defence Office. And without going into the details, Your Honour no doubt will accept from me that we have been, as we have across 3 years now, been in very regular and open communication with the head of the Defence Office and those others who work for him. I am not going to go into the details of those discussions at the prompting of the prosecution. It is wholly inappropriate for the prosecution to enter into the arena in this way. The two schemes do not run in alternative as direct alternative schemes. They complement each other. The first scheme has a different basis for criteria and assessment than the scheme that is operated by the Defence Office here, which is a more limited scheme, has more limited application, and provides more limited support, not only in terms of resources, but also in terms of who can properly access it. Both the SPO and, of course, the Defence Office and the Ministry of Justice, they are each of them organs of the Republic of Kosovo. It ill behoves the prosecution in this way to seek to exploit the failures of another organ of the state of Kosovo, the Ministry of Justice, to the disadvantage of each of these three accused, although, of course, my interests are focused on Mr. Januzi. It is an abuse of the SBO's claimed legal independence to seek to interfere in the accused's right to have adequate time and facilities for the preparation of his or her defence and to defend himself or herself through independent specialist counsel of his or her own choosing and no one else. The prosecution should not enter into matters that simply they have no locus to enter into. Whether it's called a stay, or whether it's called an adjournment, or whether, as we've put it in our submissions in relation to the Fourth Status Conference, we are simply asking the court to acknowledge the rights that the accused have, to have adequate time and facilities for the preparation of their defence. To factor that into the timetable, we all wish to reach the stage where trial preparation on both sides is complete and we can move to trial as quickly as possible. But there are difficulties that each side faces. And Your Honour knows that although we haven't engaged in the substance of the status conference yet, the prosecution have not complied with the timetable that Your Honour has set out in terms of preparation for trial, despite their overwhelming imbalance in resources that they enjoy and take advantage of. That is all I wish to say. I repeat the request for a direction to the Ministry of Justice from Your Honour with a timetable for them to comply with their obligations under law number 05/L-054 and administrative instruction MOJ number 08/2022 as in force on the 4th of December 2023 when the request was made on behalf of Mr. Januzi.
Thank you, Mr. Rees. I do not... Oh, sorry. Madam Prosecutor, then very, very briefly, please.
Thank you, Your Honour. Just to add that the SPO is not seeking to interfere in any way. Rather, we're making submissions in furtherance of the fairness and expeditiousness of the proceedings with a view towards continuity and representation for all of the accused. Regarding the administrative instruction from the MOJ, I just want to point out that pursuant to Article 3-4 of our laws for the specialist chambers, laws not expressly incorporated shall not apply to the organization, administration, functions, or jurisdiction of the KSC. The reason we bring up the comprehensive framework that is in place before the specialist chambers is to point out that there is no reason, whatever the circumstances, for there to be any kind of gap or reduction in representation for any of the accused.
Your Honour.
Thank you.
May I...
Mr. Rees, very briefly,
Yes,
please.
I absolutely understand, and I did not wish to rise to my feet again, but Your Honour will understand that there is a very well-understood protocol for submission, response, and then reply, which doesn't entitle the prosecution to keep raising to their feet, seeking to have the last word. So if I may, I will seek to reply, and then we can move on, Your Honour.
Yes, briefly, please.
I will repeat it again. The relevant law is law number 05/L-054 and the administrative instruction MOJ number 08/2022 as in force on the 4th of December 2023. That is a piece of legislation passed by the Kosovan Parliament with a statutory instrument that is authorised by it, passed by the Ministry of Justice, that deals solely with proceedings before the Kosovo Specialist Chambers. It deals with nothing else. It is, I'm afraid to say, absurd to suggest that that legislation falls outside, as the prosecution puts it, their laws in this chamber. And I know that Your Honour does not accept that for a minute. Obviously, the framework that is set out in the law of the Specialist Chambers and Special Prosecutor's Office and the rules of procedure and evidence have necessarily been supplemented by other pieces of legislation. And for example, I note that only very recently Your Honour ruled, based on a submission made by the SPO, that they were entitled to look at powers that existed under the Kosovan Criminal Procedure Code, which were not specifically incorporated into the law of the Specialist Chambers, or indeed the rules of procedure of Specialist Chambers, in relation to arrests and what procedure can follow on arrest. Of course, the framework, the legal framework of these Specialist Chambers incorporates the law that is created by the Kosovan Parliament to, as it is put, provide legal protection and financial support, covering the costs of the defence and engagement of independent and experienced counsel to any person who is accused of crimes alleged in proceedings before the Specialist Chambers. And accordingly, I ask Your Honour to make the direction that we've requested.
Thank you, Mr. Rees. I do not see any request for the floor. So before we move on to another topic, I will first, I see. Sorry, Mr. Cadman, I didn't see that you had this yellow hand on the screen. You have the floor, please, briefly.
Sorry, I had my hand up as well. So
my apologies that I didn't see.
Just to say that the request that has been made by Mr. Rees for a direction to the Ministry of Justice, we also believe is necessary regardless of what decision is made going forward. There is still going to need to be a decision by the Ministry of Justice. And finally, just to, and I'm sure Madame Prosecutor knows this very well, just to remind her that each and every accused who has stood trial before this court and currently standing trial before this court are funded through the Ministry of Justice. So to suggest anything otherwise is somewhat disingenuous. I wanted to make that point. I'm sure everybody in this court is well aware of that fact.
Thank you, Mr. Cadman. This time, I really do not see any request for the floor. So, but before I give the floor to the registry, I want to make clear that I will not leave this case hostage of the willingness of the Ministry of Justice of Kosovo to fund the defense teams. Decisions need to be taken urgently if the ministry will or will not remunerate the defense teams. In the negative, or if the Ministry of Justice of Kosovo does not make any decision in the following days, we have a legal framework. We have a legal aid system that is to be triggered if the accused do not have the means to pay for their defense. If the Ministry of Justice of Kosovo does not wish to contribute to the payment of the defense of the accused before the Kosovo Specialist Chambers, counsel shall be remunerated either by the accused or through the legal aid system. But the most important now is, as mentioned by the defense, that there is a decision from the Ministry of Justice of Kosovo. And for this, I will now give the floor to the registry to indicate first if the defense teams have asked for any assistance on this matter.
Sorry, can I just address
No, you will have the floor after I give the floor to the registry, please. Thank you. Second, if you have had any contact with the Ministry of Justice of Kosovo on this issue. Third, in case no contact have been made, if you can reach out to the Ministry of Justice of Kosovo to inquire if, I would say within 2 weeks, the ministry can solve the situation with the defense teams, and if you can report about the discussion with the ministry afterwards. And fourth, In the negative, how fast and under what conditions can counsel be assigned to ensure that the accused are duly represented? Before I give you the floor, Mr. Registrar, we will hear from Mr. Rees so that you can prepare your submissions. Mr. Rees, please, briefly.
Yes, thank you, Your Honour. Your Honour referred to the willingness of the Ministry of Justice to grant the request or otherwise. Clearly, Your Honour did not intend to encourage the Ministry of Justice to believe or be under the impression that its legal obligations are something that it is free to comply with or ignore depending on its willingness. The law, I can take Your Honour to it if Your Honour wishes. I don't know if Your Honour has seen it, but the law is perfectly clear. Mr. Januzi is entitled to legal expenses cover under the scheme that is created by law number 5/L-054 and the administrative instruction MOJ number 08/2022 as in force on the 4th of December 2023. And all we're asking is for the ministry to comply with its legal obligations. It has no choice in the matter under its own legal framework, under the law of Kosovo, of which this is a court of Kosovo. It is not a position that they have a choice in the matter. One other matter, Your Honour did touch on one of the differences, and there are many, but one of the differences between the scheme that is created under law number 5/L-054 and the residual scheme, the fallback scheme that is operated here. And that's the issue of indigence. So the two schemes are not mutually alternative. They complement each other. And in the first instance, Mr. Januzi, who has made a request in accordance with the law, is entitled to have that request granted under the law. There is no choice in the matter for the Kosovo Ministry of Justice.
Thank you, Mr. Rees. Mr. Nielsen, you have the floor. Sorry, Dr. Gary, very briefly then, because we need to move on.
Yes, I adopt the submissions made by Mr. Rees on the law. I also have a concern that you're calling on the registry in open court without us being given advance notice of the information that the registry may have. In my submission, it's very difficult for us to deal with this without notice of the sort of information that you're about to receive from the registry. May I suggest that you adjourn this status conference to tomorrow and the registry provide that information to us in writing in advance so that we can consider it with our clients. I have an appointment with my client at 2:15 tomorrow. The sort of information that the registry may be supplying may well be issues that I need to discuss with him. So in my submission, it's not appropriate for us to receive this information from the registry on the hoof, if you like. We should be given it notice so that we can deal with it. I've certainly made my submission in writing in advance to stay for a month, and I would hope that the relevant respect to the defence would be given from the registry so that we have advance notice of what they can do. I certainly wrote to the registry and explained the problem, and I haven't received a reply from the registry. In fact, the only reply I received was, please don't email the registrar, you have to do it through the Defence Coordination Office. So may I invite you not to ask the registrar to make these submissions in open court and ask the registrar to send written information to the defence first that we can consider in a future status conference, please.
We will now hear the registrar and I will give you the opportunity to respond, and if you need more time to respond, we will assess that after I receive your oral submissions. Mr. Nielsen, you have the floor, please.
Thank you, Your Honor. You have posed 4 questions to me, and I will try to answer them all. Counsel for Mr. Bahtijari and counsel for Mr. Januzi have, of course, informed us about the fact that they were in the process of securing funding from the Kosovo Ministry of Justice, and that there were some problems or difficulties with that, as they have informed Your Honors about the same thing. That's the engagement that has been on that issue. With regard to your second question, Your Honor, has there been any contact with the Ministry of Justice of Kosovo on this issue? There has not been. We have not been in contact with them. You also inquire whether we could, or registry could reach out to them, to Kosovo Ministry of Justice. If it assists, of course, the registry will be ready to do so, to see what the outstanding issues are, to ensure that they, to the extent we can, that any outstanding issues concerning legal aid are resolved. Although I'm not sure whether we are past such a measure, considering the request that was done by the defense today. But we certainly are willing to do it, if Your Honor, if it assists Your Honor. With regard to your fourth question, under what condition the counsel can be assigned, we have touched upon that already now in the session. This process starts with the accused, an indigent or partially indigent accused, before the KSE can submit a request for legal aid under the legal aid regulations. The burden to prove indigence or partial indigence is on the accused, so it's a formal application which requires, or includes, I should say, in the application a declaration of means form, various consents forms, so that authorizing release of financial information and so on, so that the defense office can verify correctness of information provided by the accused. All these details are in the legal aid regulations. Once a request is complete, the registry defense office will transmit it to the registrar for a decision. Before that's happening, an indigence assessment is being made. Once that inquiry into the accused indigence is complete, the registrar will take the decision on the legal aid request, and if it is concluded that the accused is indigent or partially indigent, then legal aid will be granted and counsel can be assigned. So that's the procedure. In terms of the time, it's a little bit difficult to say. There are certain things, obviously, that are on the registry side in terms of timing, but to a large extent also it depends on how quickly the information and the documentation by the accused can be provided. That's, I think, what I have for you, Your Honor, unless you have any further follow-up question for me.
Thank you, Mr. Nielsen. We'll now give the floor to Mr. Kadman, who is requesting the floor, please.
Thank you, Your Honor. Just to be clear, as I said at from the outset, that we have not approached the registry thus far on the basis that we have been exhausting, as far as we can, the funding arrangement with the Ministry of Justice, and at the point that the Ministry of Justice either refuses or doesn't provide adequate protection to Mr. Shala, we would then be making the appropriate applications through the registry. So I note that Mr. Nielsen made reference to the other two accused, and I just want to make clear the reason why we haven't approached the registrar thus far.
Thank you, Mr. Kadman. Mr. Rees, please.
Thank you. I'm grateful, obviously, to the invitation from the registry office that they would, if asked, speak to the Ministry of Justice. But it does seem to us that there is a straightforward solution. It's that which we've invited the court to do, which is to order the Kosovo Ministry of Justice by set a time limit, as swift a time limit as Your Honour wishes, because we all agree that certainly from my client's point of view, I do not want Mr. Januzi held hostage in this way any longer. So set a time limit as swiftly as possible for the Kosovan Ministry of Justice to comply with its legal obligations under Administrative Instruction number 8, 2022, as in force on the 4th of December 2023. If they then refuse to, because there is no discretion, there is no means testing, Mr. Januzi, as a Kosovan national, which is the only criteria, qualifies for it. If they refuse to, we will seek a legal remedy, as Mr. Januzi is entitled to do in law if his legal rights are being subverted. He is entitled to seek a legal remedy. And in order to expedite matters, the next step we would see would be that we would seek a legal remedy, and it seems to us the appropriate venue for that would be the Constitutional Chamber. And they could rule on the legal obligations of the Ministry of Justice, and they can then make a binding, enforceable order. And we would, in order to expedite matters further, because we want it to be dealt with as expeditiously as possible, at that stage, invite Your Honour not only to give the direction that we ask Your Honour to give today, but if, in the event that they failed to comply by either refusing outright or refusing to pay in accordance with the administrative instruction, we would ask Your Honour to expedite matters by making a referral by the court to the Constitutional Chamber, which ought to allow the matter to appear before the Constitutional Chamber very expeditiously, promptly. They can rule on the matter, having heard argument, and the matter will then be resolved. That is the course that we invite Your Honour to take today.
Thank you, Mr. Rees. First, Dr. Gary, and then the prosecution. Dr. Gary, please.
Thank you, Your Honour. And thank you to the registry for the information. I adopt the submissions made by Mr. Rees. They are, I hope, can be taken as the same words on behalf of Mr. Bahtijari. Also raise this concern that the combination of the registry and the Specialist Prosecutor's Office appearing to push these proceedings towards duty counsel, as has been set out in writing by the Specialist Prosecutor's Office, and or indigence, risks this court and Your Honour being complicit in the Ministry of Justice breaching its legal obligations. This is not a situation that should be, well, let's by negotiation just make sure they apply for legal aid. That's not how it works. And I would not wish Your Honour to be in a position where you are complicit in a breach of legal obligations by the Ministry of Justice, and where those obligations, at least at present, are violating the rights to a fair trial of an accused person. So we have serious concerns that everything that's going on in court at the moment is fueling our arguments on the violation of Mr. Bahtijari's fair trial rights. We would invite you, as we have said before, to give the direction that Mr. Rees has requested, also on behalf of Mr. Bahtijari, and adjourn this status conference until we know the position of the Ministry of Justice and whether or not we have to take legal action if there's a refusal. Thank you.
Thank you, Dr. Gary. Madam Prosecutor.
I just wanted to take the opportunity to point out that pursuant to Rule 201 of the Specialist Chamber's Rules on Evidence and Procedure, before a panel may issue orders to the Kosovo government, the rule sets out specific requirements, including the exhaustion of remedies, as including before the registrar, before any such application may be made or granted.
Thank you, Madam Prosecutor.
I can tell Your Honour that I am exhausted. Right? I have exhausted everything I can do to get the Ministry of Justice to give us a decision on the request in accordance with the law.
Thank you, Mr. Rees. Mr. Nielsen, you ask for the floor, please.
Thank you, Your Honour. Very briefly, just in terms of response to the counsel from Mr. Bahtijari about somehow pushing the proceedings. That was not my intention with the submission. I was simply responding to the question you asked, Your Honor, whether under what condition, how fast can counsel be assigned. That's all. The registry has takes no position beyond that. I just wanted to make that very clear.
Thank you, Mr. Nielsen. Dr. Gary, please.
Yes, if I may, I wasn't suggesting for a moment that that's what Mr. Nielsen was doing. What I was saying is there's a risk that we have a combination of the Specialist Prosecutor's Office and this court through the registry, risking the independence of Your Honour. So I wasn't seeking to insult Mr. Nielsen in any way. The point that I'm making is you have two organs of the state combining together, risking, Your Honour, allowing the Ministry of Justice to fail in its legal obligations. So I'm just identifying a risk rather than seeking to insult anyone, and I hope that that was clear in my submissions, and I'm sorry if it wasn't.
Thank you, Dr. Gary. I do not see any request for the floor on this matter. I will make decisions on this at the end of the status conference. We will now move to the items of the agenda that concern the specialist prosecutor, because whatever is decided, I do not want the prosecutor to stop working on the case, especially on disclosure and related matters. I would like to hear from the SPO on the progress made in the disclosure of evidentiary material. I have taken note of the SPO's written submissions on the issue of disclosure. Regarding the Rule 1021B material, the SPO indicated that with the exception of certain limited additional evidentiary material stemming from its ongoing investigation, it has completed its disclosures within the deadline set forth in the framework decisions on disclosure by 15 December 2023 and 19 January 2024, respectively. With respect to Rule 1023 material, the SPO indicated that thus far 2 of the 3 accused, Mr. Shala and Mr. Januzi, have requested disclosure of all items listed in the detailed notice. The SPO envisages limited challenges to the materiality of evidence. It also indicates that the majority of the Rule 1023 material will not require redactions. Finally, the SPO does not anticipate making any request under Rule 107 of the rules. The Januzi defense indicated in its written submissions that the SPO has not completed its disclosures within the deadline set forth in the framework decision on disclosure. It also considers that the Rule 1023 notice is incomplete, and I invite the parties to make additional submissions on this topic. Finally, regarding the objections to the admissibility of any evidentiary material that has been disclosed on the basis of Rule 102 of the rules, the Januzi defense indicates that it cannot commit to being able to file its objection by 22 March 2024. The Shala defense indicates that it would be able to file its objection by Friday, 22 March 2024, provided that there will be no further disclosures of Rule 102 material. I invite the parties to provide submissions on these questions, as I intend to rule on this matter at the end of the status conference. Madam Prosecutor, you have the floor.
Thank you, Your Honor. As Your Honor noted, and as we provided in our written submissions for today's status conference, the SPO has met its deadlines under the framework decisions as set forth by Your Honor, with the exception of limited 1021B materials, which we have highlighted in a corresponding filing for Your Honor that we are seeking to have admitted. I don't want to jump ahead, but I will preview, since it's related, that there are elements of the investigation that are ongoing but extremely limited in scope that have already been addressed by various decisions of Your Honor and requests by the SPO. And so we do anticipate that based on the results of those investigative measures, there may be some, again, very limited additional materials that we would seek to have disclosed pursuant to Rule 1021B. Regarding the indication from my colleague, counsel for Mr. Januzi, that the disclosures that have been made by the SPO are incomplete, we await further information regarding in what ways that is incomplete. But specifically with regard to the Rule 1023 notice, which has been provided being incomplete or deficient in some way, the first the SPO became aware of that position was in the submissions made by counsel. And we did attempt to then engage inter partes, and we have some indication now of what the perceived deficiency is. My proposal would be that we be given the opportunity to engage directly with counsel in order to find a resolution before this matter need be brought up to Your Honor directly. I'm hopeful that together we can sort out whatever difference of opinion or discrepancy there may be between our positions.
Thank you, Madam Prosecutor. Mr. Rees, please.
Your Honor, I have a sense of déjà vu. The SPO, in their submissions, asserts that they've completed their disclosures, but they haven't. So, my learned friend says they've completed their disclosures within the time frame, but with the exception of not having completed them. We asserted in our submissions that they hadn't, and their response confirms that. As to how limited or otherwise those outstanding matters are, we will wait to see. And we'll only know when they're dealt with and the SPO has completed its obligations. I'm perfectly happy to go tete-a-tete with my learned friend to see if we can progress matters inter partes. We're always there, and it only takes an email to reach out to us, and we are more than happy to engage in that way, as we always have been. I can say that in relation to the fact that the Rule 1023 notice is not complete, there's no mystery about it, and I struggle to understand why the SPO don't realise that their Rule 1023 notice is not complete, because they explain that there are ongoing investigative steps. And for example, there's no need to go into private session, but I'll be careful with what I'm saying. Forensic copies of technological material, for example, have neither been served. They're not on the list of exhibits that are relied upon by the prosecution, nor do they appear on the Rule 1023 notice. There are other items of work that are ongoing that undoubtedly will be producing relevant material, if it hasn't been produced already, that the SPO will not rely upon. The fact of their investigations will produce relevant material. And it does lead me back to earlier status conferences in other cases where still not quite sure if the SPO do understand the purpose of the Rule 1023 notice, what it does and what's supposed to be on it. But they ought to, at least by now, appreciate that all relevant material that is in their possession, that they do not serve as evidence, has to appear on the Rule 1023 notice. It's plain, because they haven't completed their disclosures in relation to the evidence that they rely upon, that there also will undoubtedly have to be updates to, in additions to, the Rule 1023 notice in due course. Does Your Honour need me to address anything further in relation to this aspect of the agenda?
No.
I can, if Your Honour wishes for further detail, we can go into private session. I can spell out for example, some of the matters that do not appear on the Rule 1023 notice at present. But as far as I'm concerned, I'm content for the SPO to acknowledge the reality of the situation, which is that their own submissions make it clear that they have not complied with their obligations to serve evidence, and they've got ongoing investigative steps to take place, and that will lead to further updates to the Rule 1023 notice, and for Your Honour to deal with that by way of appropriate direction.
I understand what you're referring to, but I will nevertheless ask the prosecution. Madam Prosecutor, do you wish us to go into private session so the Januzi defense can walk you through evidentiary material in detail?
Your Honor, my preference would be not to get into the details regarding the ongoing investigative measures. You know, these are pending matters. We don't know yet what evidentiary material may come out of the steps that we're taking. What I will say is the fact that there have been aspects of this investigation ongoing has been something that the SPO has openly addressed at, I believe, every single status conference that's been held for Case 10. When I refer to disclosures, being complete, that is, of course, the disclosure of materials that are currently in our possession. Where there is an ongoing investigation, I would think that it would be clear that there could be other materials coming. And with regard to the Rule 1023 notice, that notice is, of course, ongoing. And to the extent additional relevant materials become into the possession, of the SPO, those materials would, of course, be added to that document.
Thank you, Madam Prosecutor. Now let me turn to Dr. Gary, please.
Your Honour, firstly, I'm not sure I understand the Special Prosecutor's reply. She seems to be saying the notice is complete but not complete. So I hope that you will be able to fathom what she is trying to say. Plainly, of course, on behalf of Mr. Januzi, we would like disclosure of all items. We would like to know that the notices are complete, but I am tied by the problems that I have. I have no team, no Kosovan speaker. I have no funds to provide the evidence to Mr. Bahtijari. He probably needs to have everything printed. I have no health assessment as to whether or not he is fit to stand trial, and I have concerns about his health. I can't possibly comply by the 22nd of March with the response that you request. It's simply not humanly possible in the absence of what I need to protect his fair trial rights. I can only ask that you change that date to the 22nd of April and have another status conference to see how we're progressing. It's insurmountable on behalf of Mr. Bahtijari at the moment.
Thank you, Dr. Gary. Mr. Cadman, please.
Thank you, Your Honour. So we've put in the written submissions our position. Obviously, it's subject to what further disclosure is going to be made as part of the ongoing investigations. Of course, there is going to have to be a cut-off point at some stage that Your Honour is going to have to direct the SBO to comply with. What we have said is that as things currently stand, and I must echo Mr. Rees's concerns as to the inadequacy of what has been disclosed so far, that's obviously a matter for Your Honour to rule on. The only thing that I would flag at this stage, just to put the SPO on notice, is that we do intend to object, obviously by way of a written filing in respect of their most recent 9th of February application. So I won't go into the details of what those objections will be now, but it does correspond to matters directly relevant to Mr. Shala, but obviously that will be by way of a written filing within the time allotted for us to respond.
Thank you, Mr. Cadman. Madam Prosecutor, do you want to respond to the submissions of the Bahtijari and the Shala defense?
I don't have anything to add, Your Honor, based on what I've already said here and today.
Thank you, Madam Prosecutor. I just want to remind the parties that if any defense teams seeks to add any evidentiary material in their Rule 102.3 notice, they can raise this inter partes with the prosecution first. And it's always something that the parties can do.
There is one matter that I could raise at this stage that I think would be helpful. Your Honour may recall the first status conference that I appeared in this matter. It wasn't the first status conference as a whole. I think it might have been the second. I did raise with Your Honour an issue in relation to securing potential evidence, which we did in private session. And Your Honour made a direction for the prosecution to, in effect, consider whether they would take those steps themselves. And they did, subsequent to that, make a request for authority to secure that evidence. I'll give Your Honour the request number. It's F00143. And they made that request on the 5th of January 2024. As far as I'm aware, I haven't seen a decision on that request. It's unopposed because obviously we prompted the request to be made. But can I ask the court to issue a decision on that? I have taken it that because the SPO undertook to make that request, and they did make the request, that those steps are in hand.
Absolutely. I've indeed received this request, and the decision is imminent on this matter raised by the prosecution, because you raised it indeed in the second status conference. So this is well noted. I note that some defense teams said that 22 March was possible, at least one defense team. Another said that it was premature. Dr. Gary, you just mentioned that only 1 month later, provided that we have a status conference in between to make sure that the funding question has been resolved, would be possible. If, and I'm asking very openly to have this case moving, if I was to set a deadline 1 month after what I had planned, which is probably around the 20th of April, provided that we have a status conference to make sure that the funding issue has been resolved, would this be possible for the 3 defense teams? And let me start with Mr. Rees, then Dr. Gary, then Mr. Cadman, please.
Well, I'm certainly grateful for the offer of extending the time limit beyond that timetable which Your Honour had in mind. Can I put it this way? We will, of course, work as diligently, expeditiously as we can to meet whatever timetable Your Honour sets. So if Your Honour sets the 22nd of April, we will obviously endeavour to comply with that. If there is any issue with us complying with that deadline of the 22nd of April, we would then raise it either in a status conference, or we would raise it, if necessary, via a filing.
Thank you, Mr. Rees. Dr. Gary, please.
Your Honour, my submissions are much the same. I sort of plucked that date out of the air in a month after the 22nd of March. I don't even know if it's a Sunday. In my hope, and on behalf of Mr. Bahtijari, that we will have confirmation from the Ministry of Justice today of funding. So, of course, I will do everything I possibly can to keep Mr. Bahtijari's case on track. And if we can have that date to work towards, I'm hopeful that it will be suitable. I just can't promise anything in my particular difficult circumstances at the moment. That I really hope you understand. Thank you.
I fully understand. I'm trying to find practical solutions.
I can see that. Thank you very much.
Mr. Cadman, please.
Well, Your Honour, you already have my submissions in respect of the previous date. Just to reinforce that my very clear instructions from Mr. Shala is he is in detention. He doesn't want these matters to drag on forever. But I think in the circumstances, an additional month is not unreasonable.
Thank you, Mr. Cadman. I don't see any request for the floor on this matter. There is one last matter on disclosure that I will address today. I know that in filing F00164 distributed yesterday morning, the SPO requested to be authorized to disclose certain limited additional evidentiary materials pursuant to Rule 1021B of the rules. These further materials consist of a forensic image of a phone seized from Mr. Shala, as well as extracts of records, including text messages and call log records taken from the forensic image of the phone. According to the SPO, the analysis of the Shala phone that led to the further materials being generated had not been completed on 15 December 2023, which was the deadline for disclosure under Rule 1021B of the rules. The SPO indicates that the further materials are limited. They concern relevant material that is probative of the charges, and their prompt disclosure will allow for timely and effective defense preparations. And subject to my approval, the SPO has provisionally included the further materials on the exhibit lists as item 168 through 170. I invite the SPO to make submissions on this matter as we refer to material that is useful for the defense preparation. Madam Prosecutor.
Thank you, Your Honor. I would chiefly rely on the written submissions in filing 164, specifically at paragraphs 5 and 6. What I will add is this new material, what we call the further materials in the filing, falls very much under the category of materials that we anticipated would become available to us and then disclosed to the defense subject to review for their materiality in this case. Per that review, we have found information that we believe belongs on, or should be disclosed rather, pursuant to Rule 1021B, and that will be material to the preparation of the defense, in addition to any use we might make of it at trial. If Your Honor has any other questions, I would be happy to address those.
Thank you, Madam Prosecutor. I will give the floor to the defense on this request of the prosecution. Mr. Rees, please.
I don't think I have any submissions on this, Your Honor. Thank you.
Thank you, Mr. Rees. Dr. Gary?
No, thank you.
Thank you, Dr. Gary. Mr. Cadman, please.
Thank you, Your Honor. That was specifically the filing that I was referring to a moment ago, in which we will be filing an objection to that.
Thank you, Mr. Cadman. Let me now move to the next item in the agenda related to the SPO, which is the status of the SPO's investigations. I first note that the SPO filed its pretrial brief in case 10 on 2 February 2024, before the issuance of the joint decision, in conformity with the timeline I ordered. I also note that yesterday it submitted its Rule 109C chart and witness and exhibit lists and related requests for Rule 1021B disclosure. In its written submissions, the SPO indicated that it is in a position to file an updated pretrial brief this week, noting that only minimal changes are required from the previously filed in case 10 to reflect the joinder of the two cases. The SPO specifies that certain steps remain outstanding, which the SPO will execute as expeditiously as possible. Madam Prosecutor, do you want to add anything to your written submissions on this issue?
No, Your Honor, and I would just highlight that should the discussion on this matter require any elaboration regarding the SPO's investigation, I would anticipate asking that we move into private session. Thank you.
Thank you very much, Madam Prosecutor. Let me turn to the defense. Mr. Rees, please.
I have no further submissions other than those on paper.
Thank you, Mr. Rees. Dr. Gary, please.
My submissions remain the same. I'm slightly hamstrung. I'll do my best to comply with my obligations as I always do.
Thank you, Dr. Gary. Mr. Cadman, please.
Nothing to add on this point. Thank you, Your Honor.
Thank you, Mr. Cadman. I see that it is 11:30, which is the usual cutoff date for the interpreters for a session. So we will now break for 25 minutes and let's say 30 minutes, and we'll reconvene at 12 for a short, very short session. Thank you very much. The hearing is adjourned.
All rise. All rise. Please be seated.
We are back in the status conference. For the next point in the agenda, I would like to turn to the defense first because it relates to defense estimates. I included in the status conference scheduling order the status of the defense investigation, intention to give notice of an alibi or other grounds for excluding responsibility, intention to make requests concerning unique investigative opportunities, and whether the defense intends to file a pretrial brief and related material. And distant from the discussions we had at the beginning of the status conference that some or all defense teams might not be in a position to provide oral submissions today on this matter. So I will give the floor to the defense, and I will let them decide if they want to make any oral submissions on these issues or wait for the funding situation to be resolved. Starting with Mr. Rees, please.
Your Honour knows that our position is that until the funding issue is resolved, it's very difficult for us to commit to a timetable. Certainly, in relation to paragraph 4A1, status of our investigations, paragraph Roman numeral 2, any intention to give notice of an alibi or grounds for excluding responsibility, and intention to make requests concerning unique investigative opportunities, I would ask that we await until the next status conference, where I hope that we would be in a position to be able to give clear assistance to the court in relation to those matters. In relation to the filing of a pretrial brief, I can indicate that we do envisage that a defence pretrial brief will be filed together with related material under Rule 95(5). We have said in our written submissions that in the circumstances we cannot commit to the date of the 12th of April 2024 as initially proposed. I note that, of course, that date is, of course, earlier than the 22nd of April date that Your Honour has canvassed in relation to providing notice of objection to admissibility of evidentiary material during the course of this hearing. In order to further matters, though, and to be constructive, which I know Your Honour wishes us to be, if Your Honour was to set a date beginning of June to file a pretrial brief, I would not object any further and work to that timetable.
Thank you, Mr. Rees. Dr. Gary, please. Microphone, please.
You'd think after all these years you'd remember to unmute yourself. I'm very sorry. May I suggest the 22nd of June? It's a little bit later than Mr. Rees. I have the health issues that I keep mentioning that will impact on my ability to take instructions. I'm also in a situation where it doesn't appear, and I don't want to criticise duty counsel at all, but it doesn't appear that the sorts of investigations that one would wish to complete on behalf of a client have taken place in advance of my arrival. And I had access to the workflow on the 19th of January, largely because someone thought I was a man called Jerry instead of a woman called Gary. There were problems with my access to the material. So the sort of time that other teams have had to further the case, unfortunately, it hasn't been available to me on behalf of Mr. Bahtijari. Plainly, he and I meet regularly, and I am in a position to make those inquiries happen, produce the relevant paperwork, comply with my obligations, and do everything that you would wish me to do on his behalf. But realistically, it will take me longer, particularly because I do have the concerns that I have about his health. So I agree with Mr. Rees. I think I need more time. That's not to frustrate the court in any way. It's being realistic. So might I suggest the 22nd of June so that we can have sufficient time to provide everything that we should be providing, assuming my funding is in place today. I've checked my emails. I don't yet have anything from the Ministry of Justice. Again, I'm a little bit hamstrung. I'm very keen to help the court. I think it's sensible to set a timetable. I will do my utmost to comply.
Thank you, Dr. Gary. Mr. Cadman, please.
Your Honour, has our written submissions on this point and the other questions that you asked in terms of defence investigations and other applications that may be made. I don't seek to add anything further now, only to say that we had put in the written submissions that our ability to abide by any deadline was subject to the prosecution's updated, amended pre-trial brief, which we've heard will be filed this week. I do raise the issue that whilst we have a joint case, we still have two separate operative indictments. And so obviously that position is going to have to be resolved at some point. But at this stage, I'm not objecting to anything further in terms of the dates that have been discussed.
Thank you, Mr. Cadman. I don't see any requests for the floor. Let me move to the next item in our agenda, which is the agreement on points of law and facts. I note that on 5 February 2024, the SPO circulated to all accused via inter partes email a list of proposed agreed facts, but the defense teams indicated that they were not able to respond. I wish to recall the parties that there is no obligation from the parties to agree on matters of law and fact before trial. Madam Prosecutor, you have the floor on this topic.
I'll rely on our written submissions and just reiterate that if at any point counsel for any of the accused wish to engage with us on the draft that we've circulated regarding proposed points of agreement on fact or on law, we would be happy to engage in those discussions.
Thank you, Madam Prosecutor. Mr. Rees, please.
Nothing further on my part.
Thank you, Mr. Rees. Dr. Gary, please.
Yes, I hope to be able to engage meaningfully with the specialist prosecutor. I'm still outstanding my apology for their filing in relation to me. And of course, I will do my best to engage with a specialist prosecutor that is currently still insulting me. But I will do my best on behalf of my client. And if agreement is possible, once I've taken instructions and he has had his health assessed, of course, we will do our best to agree. It would be helpful if the specialist prosecutor would apologise. I'm sure that would progress matters.
Thank you, Dr. Gary. Mr. Cadman, please.
Thank you, Your Honour. We have communicated. I'm not sure if the SPO has had an opportunity to receive the email that we sent this morning. We hadn't said that we wouldn't engage. We just hadn't responded to their 5th of February request. We have responded to that, setting out that we will happily engage, but obviously it's subject to certain matters that as of today's date still remain outstanding. I think it's in the interest of all parties that there is a discussion as soon as possible on these matters. I would highlight that one of the issues that we have encountered in previous matters, certainly on agreement on the law, I'm not sure to what extent we will have an agreement, but by having no agreement at this stage on what the elements for each of the offences that need to be proved, certainly Mr. Rees and I have had that discussion in a previous matter that has caused difficulties in moving forward. Certainly I would be open to having that discussion. Ultimately, it may be a matter for a judicial decision, but certainly there should be some agreement as to what the elements of the offences should be.
Thank you, Mr. Kelman. Madam Prosecutor, do you want to reply?
Yes, I just want to reply briefly to counsel for Mr. Bahtijari to say that the SPO's filing was not an insult. It was not personal. It was made based on the applicable framework here at the Specialist Chambers and, in service of fairness and expeditiousness. And as I've said, we stand ready to engage on the legal issues here with counsel whenever any of the counsel so choose.
Thank you, Madam Prosecutor. I don't see any request for the floor. So we will now move to the last topic in our agenda, which is the transmission of the case file to the trial panel. But I will not seek detailed submissions of the parties on this matter, given that we haven't sorted out the first issue we discussed at the status conference. So unless I see a request for the floor, this will be discussed during the next status conference, and I don't see any request for the floor. At this point, I would like to ask the parties and the registry whether there are any other issues they would like to raise, starting with the prosecution office. Madam Prosecutor.
Nothing from the SPO, Your Honor.
Thank you, Madam Prosecutor. Mr. Rees, please.
Yes, two matters. Facilities for remote legal consultations is the headline that we have given it in our written submissions for this conference. I can break that down into two elements. Your Honour may recall that some time ago the SEDS system was set up to allow the transfer of digital material remotely between counsel and lay client at the detention management unit. There is a real issue, it seems to us, in that at one end of the transfer, the folder system is full of material, and yet it doesn't seem to be accessible to Mr. Januzi in the Defence Management Unit. I attempted yesterday to take facility, a laptop with Wi-Fi access to the Detention Management Unit so that myself and my lay client could look at the system together and see if there was a solution to this. But for reasons I understand, that was not allowed, although on an earlier occasion we were encouraged, in fact, to do that. But be it as it may, I do ask that somebody at the Detention Management Unit sits down with Mr. Januzi and addresses this and either finds a solution to it or demonstrates what counsel and accused are doing wrong. I've been using that system for some time, so for my part, I can't fathom what is taking place.
If you may, I will give the floor immediately to the registry before you raise your second point, so that we already have an answer on this point. Mr. Nielsen, can you make submissions on this question, and especially if help can be given to make sure that everything works properly? You have the floor.
Thank you, Your Honor. Yes, is the short answer. Assistance can be given. I hear about the problem first time now, so we'll reach out to whoever needs to be reached out to within registry to assist with this.
Thank you.
Thank you, Mr. Nielsen. Mr. Rees, please, your second point.
The second matter relates returns to a topic that I did raise at the end of the last status conference, which is the provision of actually a physical room for consultations to take place in the detention management unit. Specifically, when in the last two remote legal consultations that have taken place, Mr. Januzi has been placed in front of a lavatory, something which we regard as frankly degrading and humiliating. Shouldn't be asked to undertake a legal consultation sat in front of a toilet. It's just not right. That is a recent development. It hasn't happened until I think the beginning of this year. I'm not aware of it. I've never seen that take place anywhere, and certainly not in the Constable Specialist Chambers before. But placing Mr. Januzi in those circumstances for a professional legal consultation is degrading, and it shouldn't happen again in our respectful submission. I'd ask Your Honour to make that clear.
Thank you, Mr. Rees. We'll give the floor to the registry. Are you aware of this, and what solutions can be provided so that it doesn't occur again? Mr. Nielsen.
Thank you, Your Honour. Again, I hear it for the first time now. There is no, would be no obstacle for the Council to reach out to us before if there are these issues. I'm sure it will be resolved, without any problems.
Thank you, Mr. Nielsen. I invite you then to continue the discussion with Mr. Rees to make sure that this issue doesn't come up again. Mr. Rees, do you have any further submissions?
Only this, that I just find it remarkable that anyone ever thought that it would be appropriate, that it ever occurred to anyone to place Mr. Januzi in those circumstances. But obviously I welcome Mr. Nielsen's commitment to ensure that doesn't happen again. And no doubt, not only in relation to that aspect, but in general, convey the message to the Detention Management Unit that due care and attention should be given to ensuring that those detained and in their custody are not treated in degrading fashion. Thank you.
Thank you, Mr. Rees. Now let me turn to Dr. Geary, please. Any further submissions?
No, thank you.
Thank you, Dr. Geary. Mr. Cadman, please.
Yes, Your Honour. One point that we had put in written submissions that hasn't been dealt with. I appreciate the point was put in for the prosecution to respond to translation issues, which they have obviously responded to. Just to re-emphasize the point, there is a practice of the specialist chambers to only provide core materials translated at appropriate times to accused appearing before this court. Just to remind ourselves that this is a national institution of the Republic of Kosovo. Mr. Shala is a citizen of the Republic of Kosovo. He doesn't speak English. He can only access that material in a language that he understands. So I make the point that all material, as far as is possible, needs to be provided to him in a language which he understands so that I am able to take instructions. As Your Honour will be aware, having appeared in the Haradinaj and Gunsati case, we are still receiving now material having been translated that should have been translated during the trial. I raise that as a point of general concern that the registry really needs to pay attention to this, that we are not sitting in an international tribunal. This is a domestic court, and he is entitled to have all of that material translated in a language which he understands. That would be the first point. I'm not expecting Your Honour to make any ruling on that, but all parties need to seriously consider that to ensure that his fair trial rights are respected. The second point, leading on from what Mr. Rees has also stated in terms of the general conditions of detention, there is a very real concern as to the recent decisions that have been taken by the chief of the DMU in terms of limiting family visits to a period of 10 days per month. There is a procedure, and we have filed a formal complaint with the chief of the DMU. It may well be that that's going to come before you if no steps are taken. Just to remind ourselves that Mr. Shala is an accused person. He's on remand. He's not serving a sentence. Having such limitations on his family visits, we say, is in breach of Article 8 of the ECHR, which, of course, this court has to be mindful of. Subject to what decision is taken, we may have to come back to you. What I have put in the formal complaint to the chief of the DMU, it is not what others may or may not have done in the detention unit that should cause as any limitation or restriction on Mr. Shala's rights. He comes before us, a man who's entitled to be guaranteed the presumption of innocence. He has had no findings against him in the DMU, and forcing his family to confine their visits to a 10-day period is not always possible. So I do ask that the appropriate authorities take this very seriously. And obviously, if no decision is reached following our formal complaint, then we will have to bring that before Your Honour for a ruling.
Thank you, Mr. Cadman. Madam Prosecutor requests the floor. Briefly, please.
Just on the translation issue raised by counsel for Mr. Shala, I wanted to say that the law on the Kosovo Specialist Chambers and the rules of evidence and procedure provide for the translation requirements in order to ensure that a fair trial is made available to all accused. And I just want to note that in connection with the translations that do need to be prepared, for instance, of all the evidence, all of that has been done, oftentimes, at full capacity at the SPO, under great time pressure, and we have ensured that all of those translations are prepared. So pursuant to the law and the rules, there is no fair trial issue here.
Thank you, Madam Prosecutor. Mr. Registrar, do you want to make any oral submissions?
Thank you very much, Your Honour. As for the translations, the Council might have been referring to evidentiary material, which is obviously for the Specialist Prosecutor's Office to respond to. With regard to filings, I refer Council to Policy on Translation and Interpretation, the Registry Practice Direction, which sets out in some details the priorities for translation of different documents. We have, as we've done in previous cases, welcomed the defense to reach out to us if there are certain documents that they would like to have prioritized in terms of translation, and we'll certainly take that into account. And more often than not, I would say we have been able to accommodate that. So if there are specific documents that are of concern, Council is invited to address us. That's with regard to translations. With regard to the second matter raised as to visit conditions at the detention management unit, as Council indicated, this is indeed a subject of a complaint and is following that procedure. So will not comment further on it for that reason. Thank you.
Thank you, Mr. Nielsen. I see that Mr. Cadman has requested the floor. Mr. Cadman, please, briefly.
Just very briefly to respond to that. Obviously, reference to the legal framework of this institution is not sufficient if that legal framework is in breach of the obligations under the European Convention, as Your Honour will be very much aware. Also, it's for all state institutions to organise themselves in such a way is that they are compliant with those obligations. So the fact that it's contained in the rules or a practice direction that still may be operating in breach of the ECHR is not a sufficient response. Again, I repeat, this is not an international tribunal. He is entitled to have this as a matter of international law, for which these institutions are clearly bound.
Thank you, Mr. Cadman. I don't see any request for the floor. So I will now issue oral orders on what we discussed earlier and an oral order related to access rights in light of the joinder of the two cases. I will now issue a first oral order. Having heard the parties and noting the urgency of the issue concerning the funding of the defense teams, I hereby order the registry to make urgent contact with the Ministry of Justice of Kosovo, emphasizing the urgency of the issue, and to inquire on the funding status and anticipate time schedule for the Ministry's decision, and to report thereupon by Tuesday, 20 February 2024. This concludes my first oral order. I will now issue a second oral order. Having heard the parties and considering the stage of the proceedings, that the pretrial stage is ongoing, and that the case has yet to be transferred to the trial panel, I find that no prejudice is caused to the defense at this stage by a continuation of the proceedings. Furthermore, I note that the registry has been tasked to speak with the Ministry of Justice of Kosovo in order to urgently resolve the question of funding. I hereby reject the stay of proceedings request at this stage. This concludes my second oral order. I will now issue a third oral order. In light of the joinder of Case 10 and Case 11 and the discontinuation of the Case 11 case record, I find it appropriate to receive submissions concerning the access rights to be granted to the respective parties. I hereby order the SPO to file its submissions by Tuesday, 20 February 2024, and to address the following. 1. What filings and decisions from KC-BC-2018-01 since the filing of its submission of 15 December 23 on the transfer of filings, which are F00136 in Case 10 and F00020 in Case 11, can be made available to all three accused. 2. What filings presently classified as confidential in each respective case can be made available to all three accused. 3. What filings presently classified as strictly confidential and ex parte in each respective case can be reclassified and made available to all three accused. Relatedly, if the SPO objects to the reclassification of the filings, whether it can file a confidential redacted version or indicate why it cannot be done. 4. What filings identified in the SPO submissions regarding the reclassification of filings in Case 10, which are F00117 and F00090, can now be reclassified. The defense is instructed to respond to the SPO submissions, if it wishes, by Tuesday, 27 February 2024. No reply will be entertained. This concludes my third oral order. And I will now issue a fourth oral order. Having heard the parties and considering any challenges by the defense to the admissibility of evidentiary material that has been disclosed on the basis of Rule 102 of the rules, I hereby order the defense to file their objections, if any, by 22 April 2024. This concludes my fourth oral order. This concludes today's public hearing. Further status conference will be scheduled in March in order to make sure that what we discussed this morning has been resolved. And in the meantime, I thank the parties and the registry for their attendance. And as usual, I thank the interpreters, audiovisual technicians, stenographers, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.